James Pilley from Wade Law Group. This is really part 2 of our segment on prosecuting and or defending or being involved in a partnership dispute. And so today, without further ado, I'm going to have Mr. Pilley talk to you about how long he's been practicing and what he does and why he does it.
Hi again, James Pilley. I'm a 13-year attorney. And why I do it? Because first and foremost, I consider myself a problem solver, and I really like to help people who have problems, be it business, real estate, construction, contract disputes, any dispute really. I like to help them understand their dispute and help them resolve it, if at all possible.
All right, so today we're going to start with the concept of mediation. So when you're involved in a lawsuit, typically the lawsuit has a component in it that it involves mediation. And so today we're going to talk about that process. So can you just let the audience know from an overview perspective what mediation is and the purpose of it?
So mediation is an informal dispute resolution process. It's voluntary, first of all, and it's where you go before a neutral mediator who listens to both sides' statements and tries to help the parties come together and resolve their dispute.
Okay. So if you're representing a client in mediation, what types of things do you tell the client in preparation for the mediation, if anything?
Well, I tell the client that when I'm preparing them for mediation, I don't know if this is the best answer to this question, is that the mediator wants to resolve your case. They don't get any points for having you walk away. So they're not going to tell you how great your case is. They're generally going to tell you all the problems with your case, and that's not something to get disappointed with or frustrated with, but understand that the mediator is trying to get the parties to come together and resolve their dispute. The mediator told you how great your case was. He'd never get anybody to resolve their case. So he's certainly going to point out the flaws and issues that you're going to have going to trial. And not to get frustrated on that, I will help you assert how good your case is, but understand that this is a way for the parties to understand their weaknesses in their case and try to find a way to resolve it without rolling the dice and going to trial, and the cost and the stress associated with that.
Okay. So typically, who is this mediator and how is this mediator selected typically?
Well, I don't know if there's a typical mediator. Most people would say it's a retired judge, but there are many types of mediators. Not all of them are judges. Some of them are attorneys who have been in a particular field for a very long time, and they probably have taken some kind of instructional course or some kind of gone to some kind of mediation or alternative dispute resolution college. And they're someone who has seen a lot of cases. They are well adept at getting to the root of the issue very quickly, and are also someone that's able to impartially encourage and coach the other side, the sides, to find common and middle ground in order to resolve their dispute.
All right. So what do you say to the person out there who says, I don't need an attorney, I can go to mediation myself? First, let's talk about what is provided to the mediator before the client even gets to mediation.
Sure. So usually you're going to give them some kind of brief that sets forth your position, the facts that support your case, why you think you have a strong case, and then certainly your settlement position, what you'd like to achieve from mediation.
So it's typically the brief. I mean, most clients don't have anything related to legal training. Is that something normally that a client can do?
Possibly. It probably wouldn't be well written, but you're going to want to kind of set forth points and authorities, case law. Some mediators don't really want case law. They know the law. But you're certainly going to want to be able to put forth the most salient facts, the most important facts, and talk intelligently about what kind of case you would put on if you were forced to go to trial.
Okay, so you're at mediation, and I've had clients who say, okay, I want to talk to the mediator, I want my chance to talk, and I want to tell the mediator what I want. What do you say to that type of client as far as what they should be saying and what your role is in the mediation?
Well, like I said at the beginning, the mediator is not going to pat you on your back and tell you how great of a case you have. They're looking for facts and weaknesses in your case that they can exploit to get you to settle. Okay, so if you offer up too much information, that might cause you to be have a weak position. The other thing is, after you get past the the stating of the facts and the stating of your case, it is a bit of positional bargaining. You're going to go back and forth with the mediator on your settlement position. And there's a lot of strategy involved in how you go about negotiating settlements, especially when they're monetary. It is positional bargaining, so it's you go high if you're the plaintiff, the defendant goes low, and you meet somewhere in the middle, right? And there is it's more strategy than legal, and knowing how and when to make moves is important. And I would say, even though an individual thinks that they're a good bargainer, someone that's been in that chair quite a few times and has seen how these cases get negotiated, that's probably going to serve that person well. Going at it alone, there's an old adage, a person who, I'm going to botch this, but a person who has themselves as a client. How does it go? You probably know it. I'm botching this. You're going to have to erase this. Sorry. A person who has themselves for an attorney has a fool for a client.
All right.
Yeah,
That's it. Yeah. Okay. So, I've been, I don't know, I've been to a lot of mediations, and I've had some clients tell me, look, just wasting time. I said I would, I'm able to accept $200,000. Why are you stringing this out? Let's just tell the mediator what I want so we can get out of here. What do you advise a client who wants to rush through the mediation and just, offer up what they're willing to settle for at the beginning?
Like I said, it's a positional bargaining, and by positional bargaining, I said it's high. You go high, the other side goes low. If you give away that your position, your settlement position too early on, you're going to lose that ground, and you're probably going to end up paying more to settle that case. You want to guard that settlement position, and a lot of my clients, I talk to them before we go into mediation, and I have them establish 3 numbers. Okay. What you would be at, I call it the pie in the sky number. Okay, if you're a plaintiff, the amount that if the other side paid you, you would be ecstatic about. Okay, and then I have them talk about their middle position, and that's that you would be pretty happy with. And that's the position that you guard very, very tightly. Okay, and then you have your third position, which is unless you can get that amount, you're going to trial. Okay. And you want to guard that middle position. You may come out the gates and offer your top position. And that way you have a lot of runway between that position and the third position. And I try to guard my middle position, that middle number that you would be happy with, by making incremental concessions, okay, that will get me to that position. And one of a key to settlement, most mediators will tell you they know based on your opening statements where the case is going to settle, if it's going to settle. And it's usually that middle position in between your opening offer and the defendant or the plaintiff's opening offer. So the two offers on either side of the table. And the way that you decrease or increase your settlement position during those bargainings signals to the other side the weakness or strength of your case. And so it is a very strategic dance that you must play when you do this kind of bargaining and mediation. And if you think you can go at it alone, you'll probably end up losing more than you would get if you had someone helping there, encourage you and coach you, who's sat in that chair a number of times and done the dance.
What do you say to the person who says, well, I want to go to mediation, but I just can't stand the other side. I can't stand being in a room with that person. I don't want to do the mediation because it's too emotional. What do you have to say to that person?
Well, most mediators, and anymore, a lot of mediation is done virtually, so you won't be in the same room with them. But years ago, it wasn't done virtually. And if some mediators still want you to be in a mediation office, but usually you're not going to be in the same room with the opposing side. And if you are, it's not for very long. and it's essentially just an introduction and the mediator telling the sides a little bit about himself, so the parties know who the mediator is. And then we do what we call caucusing, and each party goes to a room. Nowadays we do it mostly virtually, and so you'll be in a breakout room on a Zoom, and the mediator will go in between the two sides and facilitate settlement negotiations.
Wow, okay. Okay, so let's suppose that the parties are fortunate enough to reach an agreement during the mediation. How does it end? What happens at that point?
Well, you're going to want some kind of agreement, certainly. Sometimes the mediator will facilitate the settlement agreement, and generally you're getting just down the core terms, and that's going to be the core terms of your settlement, and then an agreement between the parties that they're going to go back and formalize the settlement in a more formal agreement. But generally most settlements are monetary, but if there is some kind of other component, you're going to talk about payment, whatever that other component is, how long there is to make payment, and a lot of the core terms that settlement is. Because if you walk out of there without something in writing, people change their minds.
Okay, so we've talked about the beginning of the case, discovery, mediation, and now we're down to the last phase. And you've already indicated that it's pretty rare for someone to get to the last phase. So before you get to trial, after mediation it didn't work out, what types of things, what kind of pretrial stuff is done before you get to trial?
Okay, well, it depends entirely if it's a bench trial, which is just in front of a judge, and a jury trial. And so there's a marshaling of evidence, and you work with the other side to prepare pretrial binders and pretrial statements, and if there is going to be a jury instructions. And you work with the other side to kind of get this list of these, what we call trial binders, together to put in court that has all the witnesses, all the evidence, and all the instructions if there's a jury that's going to be brought in at trial, and then a little roadmap for the trier of fact about what the case is about.
Okay.
And pretrial motions, if there's any pretrial motions, like motions in limine to exclude evidence, those would also be included.
All right, so we've done all that pre-trial stuff. Finally, let's suppose it's a jury trial. We start picking the jury. What's that process about?
So that process, we call it voir dire. I don't know, certain people call it, it's a Latin phrase. I've seen people say it differently. But anyways, the jury selection, you have two reasons to exclude jurors, and you're asking pointed questions to determine whether someone's going to have a bias against your case. And that's why you would excuse a juror. And you're trying to get some jurors that are going to look at your case impartially.
I see. Okay, so we're on the verge of trial. Right before we start producing evidence, the attorneys give something that's called an opening statement. Can you explain to the audience what that is about?
Okay, so the opening statement is a roadmap of the case, and the attorney giving the opening statement is going to set out a broad view of the facts of the case and try to probably hone in on things that you should pay attention that are going to matter in the case. But the idea is that you keep it brief. The facts haven't been established yet. You're not trying to bore the others, the jurors or the judge at this point. You're just trying to give them an overview of the important things in the case and why your client's going to win.
All right. So you've done the opening statement, and let's suppose you're prosecuting your case and you call your own witness. That's direct examination. What is that process about?
The direct examination is a friendly examination. So at this point, you've spent a lot of time with your client. If you've gotten to trial, you've spent months, years with your client developing their testimony and what they're going to say. And certainly, as you get closer to trial, you're spending a lot of time with this person. And you have developed the kind of evidence that you need to come out of your client's mouth to win your case. And so they're not any trick answers. It's pretty much you're asking them questions that you already know the answers to. Certainly any questions in a court are questions that you should know the answer to, but it's a dialogue with your client to elicit the evidence that you need to prove their case.
All right. And then you do your client, and then you do the other witnesses as well. Those are friendly witnesses as well? The other witnesses in support of your case?
In support of your case, except for cross-examination.
Right, I understand. Okay. So in your case, you bring your client and any witnesses that may be favorable to your case, and then you, I guess, that's where you submit your documentation and any evidence that, I guess, supports your case, you're going to be putting on in your case in chief.
Or you're talking about halftime, the halftime in the case, like you put on your case in chief, and then you're going to go to the defense side.
Right, before you rest, right, yeah.
Okay, yeah. Every trial is different. The way that the judge wants to run the case. Sometimes you'll do crosses right after directs. Just the way that you have to understand that if it's a bench trial, the judge is more or less a referee, and they determine how they want the case to proceed most expeditiously, generally. And so you're always mindful of witnesses, especially third-party witnesses' time. So you don't want to have them come back, multiple days. So you may do if it's your direct examination, the other side would do cross at the same time, or if it's their witness, you might do cross at the same time.
Okay. All right, so let's talk about cross-examination. So what is that, basically?
So a cross-examination is an unfriendly witness, someone who doesn't want to help you prove your case. And so you are asking them pointed questions to either establish your case or destroy theirs. It may not always be the defendant. It could be someone that's helping them prove their case. These are questions that, and I always like to tell my clients, there are no surprises. There shouldn't be any surprises at trial. Certainly if there are surprises, you're going to make something of them. But these are questions that you've already asked. We talked a little bit about deposition and discovery. These are the questions that you're going to ask in discovery, in cross, are questions that you've already heard the answers to in either a deposition or that you've received some kind of information in discovery. And so you're going to ask them generally yes or no questions that help you prove or disprove your case.
Great, great. I see. Okay, so you've gone through the trial, you've gone through cross-examination, the closing argument. What is the closing argument about?
So the closing argument is marshaling all the facts and evidence that's put in to kind of fill in your opening, your general outline of a case. And so that if the opening is your outline, now you're going back and this is your summary or conclusion, saying, remember all those things that I told you need to look out for that prove my case? Well, I've established them all, and you point to all the different things in the case and the evidence that prove your case and sum it all up and show why you should prevail.
All right. So let's take the situation where we have a jury trial. All the evidence has been in, the closing arguments have been made, and a lot of the people out there are saying, great, my case is over. What happens at that point?
Well, there might be some discussion about jury instructions. Hopefully that's already been determined, but there will be instructions. If it's in the fact a jury trial, if it's a bench trial, let's step back. If it's a bench trial and there's a judge, you'll probably be asked to write statements of decision, putting on why you believe you should have won. And it's essentially an order for the court to read and rubber stamp the one that they like or edit it to make it the judgment of the court. Now, if it is a jury trial, then you're going to have a set of predetermined questions that the jury are going to answer using the facts and evidence in the case to come up with the legal conclusion of whether a cause of action has been proven or disproven.
All right. And then for the people out there who wants their case to be over, how long can that go on?
I mean, it can go on quite a while. If it's a close call, it can certainly take weeks. The jury can even come back and ask for clarifications or representation of certain evidence that they need to make their decision. So it's not an expeditious, it's a case-by-case analysis. Certainly, if it's a very easy case, it could be decided very quickly, within the day. But if it's a very intensive fact pattern, a lot of causes of action, it can certainly go on for a long time.
All right. So, and you alluded to it. If it's a bench trial, then how long can the ending last? You talked about the judge wanting statements of decisions, and so what are we talking about with respect to having the case be over?
In a bench trial, bench trial, the judge wants it done, and so that's why he has you write your statement that he's either going to adopt, and the court, no one tells the court how long to take,
Right.
But certainly it's usually within a week you're probably going to have your decision after you submit your a week to a month, you're going to have your decision.
So it still could take some time. It's not
still
going to
can
end
take
at the
some
end of the day. when
Yeah,
you're
no,
done
no,
with
it
the
does
closing argument.
not. There's a lot of stuff that happens after you wrap up all your evidence, especially even in a bench trial, probably more in a bench trial.
Okay, so then we're almost done. So what do we talk about when we have the client say, I went to trial, I lost the case, I want you to go back to court and basically fix what I messed up and try to get the judge to change his or her mind. What are the remedies available to someone who
There are
basically has
motions
lost?
for reconsideration and there are appeals, you know, and you have time frames to do each of them. It's at that point, it's mostly preserving your record for appeal, and then making your appeal. And there's strict statutory time limits on each of those.
I see.